Welcome to the Bar of Ireland podcasts. In this instalment, we are sharing a recent seminar held by the Bar of Ireland. In this session, experienced advocate, arbitrator and mediator Joseph Matthews joined Turlough O'Donnell, Senior Counsel, for a conversation on mediation and conflict resolution, with some discussion of the Northern Ireland Troubles Legacy and Reconciliation Act.
Well, everybody is very welcome. It's great to be back to see so many old friends. I've retired now, as many of you know, and I'm doing a little bit of mediation and other things associated with that. I'd like to welcome the Chair of the Bar Council, Sarah, for her presence here, and all of you, and to say that I'm billed as chairing this discussion with a great friend, Joe Matthews, distinguished trial lawyer from Florida. But we thought we would have a dialogue, and we've been dialoguing a bit by email and as we've been speaking here before arriving. And consistent with that, if anyone would like to chip in or ask questions, make a comment or a contribution in the spirit of dialogue, that would be really wonderfully well received by both of us and helpful to both of us, because this area that we're discussing is essentially collaborative. You learn as you try to explain, you learn. So please feel comfortable, very comfortable about chipping in and adding views and clarifying matters. I'd like to also welcome my friend Liam Herrick here, who's Chair of the Irish Council for Civil Liberties. Now, without more ado, I'd like to introduce you to Joe Matthews, to tell you that he is a graduate of the University of Miami School of Law, where he was editor of the Law Review and recipient of the Wesley Sturgis Award. He's has a very distinguished career as a trial lawyer in the United States. He's a fellow he is currently a fellow and was a former president of the International Academy of Trial Lawyers. He's a fellow of the American College of Trial Lawyers, a member of the American Board of Trial Advocates, and a member of the American Law Institute, and an honorary bencher of Court of Northern Ireland. And on that note, I would like to say that he has been a wonderful friend of the Irish bar here and the bar in Northern Ireland as well, and has done wonderful work in that area, and indeed is someone who is widely travelled and experienced in other jurisdictions as well. But we particularly appreciate the contribution of the International Academy of Trial Lawyers to the bars, north and south, and Joe's contribution in particular. He seems to me, apart from the distinguished trial lawyer career I've spoken about and his practice as a mediator in Florida, he seems to be a person who simply goes around helping other people as best he can. He's a wonderful friend, and I'm very happy that he is here amongst us. He has been an arbitrator, practices as an arbitrator, served for 12 years as a member of the board of directors of the American Arbitration Association, a leading arbitration association in the United States, many of you may know about. And he practices also as a mediator as well. I'm going to start right away by jumping in right away and saying, I understand, Joe, that you have compulsory mediation in Florida, and I want to hear a little bit about the experience of that, how long that has been going on, and has it caused problems with American trial lawyers?
Thanks for starting out with a nice, easy one. First, thank you very much, Turlough. I just want everyone to know that it has been an honor and a joy to work again with a man I have admired and loved for a very long time. And to see him greeted back to the bar has been as exciting to me as being here with you now. In the United States, as I'm sure all of you know, there are 50 separate legal systems also combined with the federal system. Through nothing that I did, more than 30, almost 35 years ago, the legislature of the state of Florida, which is my primary practice, I practice elsewhere, passed a series of laws, basically a statute that developed a number of different alternatives, including non-binding arbitration, mediation. For today's purposes, the most important piece of that, and the one that was most controversial at the time, I assume fairly controversial here, was that the legislature, this was not the courts that did this in Florida, it was the legislature, said that no civil case, and by that generally I mean contract actions, tort actions, and no family case, both divorce or dissolution and child issues, can go to trial without having been mediated. Every case for more than 30 years has been required to be mediated. I was probably a 12 to 15-year lawyer at the time this first started, something in that range. All I wanted to do was try lawsuits. That's all I cared about. We do not have a divided bar, but as you heard, we have a lot of voluntary and honorary trial bars, and I wanted to be a member of every one of those, and every one of them required that I try cases. And so I and almost every lawyer that I knew was violently opposed, not just opposed, violently opposed to that and a few other related types of statutory steps that we thought were designed solely to prevent us from getting our clients' cases to judges and juries. I think over the ensuing 30 plus years, there is no question that probably every objection you have either spoken about or thought about, and a lot that you never thought about and that I never thought about, have been litigated. There are hundreds and hundreds and hundreds of cases in the state courts of Florida, which are 3 levels: trial court level, an intermediate appellate court level, and a state Supreme Court level, that have interpreted various aspects of that statute, which is not real complicated. It just simply says every case has to be mediated. What is good faith mediation? Who needs to be present at the mediation? Can the parties be compelled to have non-parties present? Can non-parties be present because of the confidentiality requirement? There are so many issues that have been litigated over and over and over again in the state courts. I can safely say to you, not that Florida is better at mediation, not that Florida is worse at mediation, but nobody does it more than we do. And as a result, there's just the broadest possible array of examples, of experiences. I was a consumer of those services for most of, 25 years anyway. It's only in the last 5 or 10 years that I essentially went back to school, retrained, tried to develop skills that are still advocacy skills, but different. My wife told me I should do it because it would make me a better person. She was wrong, but I did it, and now I do a great deal of mediation. My experience, however, has been zero in family. I've never mediated a family case. I've never handled a family case as an advocate or as a lawyer. The vast majority of the cases that I've dealt with, both in my practice and now as an arbitrator and or a mediator, are commercial in nature, heavy emphasis on insurance, large emphasis on real estate construction, transnational business disputes, and the like. So most of my specific experiences, I think we're going to talk about those, will come from that background, only because for 30 years I was not serving as a mediator. I was selecting or participating in the selection of mediators, and then employing their services as part of the process of getting my clients' cases to trial, which is what I really wanted to do.
I was explaining to Joe, I think it's still the case here that we only have compulsory mediation in personal injury cases under Section 15, Courts and Civil Liability Act 2004. I don't think we have mandatory mediation in any other circumstances. We have the judicial invitation to parties to mediate and an adjournment to allow parties to ponder on that. And I was telling Joe, and I think all trial lawyers would agree, a judicial invitation is not to be lightly disregarded. But my experience here, because we don't have that experience that Joe has outlined of 30 years compulsory mediation, my experience in the two cases of compulsory mediation that I was involved in, one as a trial lawyer seeking an order under Section 15, another as mediator. Oh, the tension. We had to talk people down at the mediation. There was resentment. And what Joe has mentioned to me is that one of the advantages of compulsory mediation is you get over the weakness argument. People, as you know, sometimes will say to us, I don't want to show weakness. I'd like to also welcome the President of the High Court.
Speaking of the judge's invitation.
And we're just talking about the judicial invitation to mediate. Shouldn't...
You did a fine job.
And we were saying the judicial invitation to mediate should never be taken lightly, and never is taken lightly. But compulsory mediation gets over the weakness argument, because the client who says, will I be showing weakness if I mediate, is obviously told, you don't have an option. No one has an option. There's no weakness here. Go mediate. So anybody has any views and experience of compulsory mediation here, it seems to me to be rare, and the courts have not ordered it in every case, which is also interesting. But chime in at any stage, please, with your experiences or questions, observations. The other thing I was going to ask Joe, amongst many other things, is does he provide an evaluation to clients at mediation? And if so, how does that work? Now, our situation again is that it's tied to evaluation. We can't give proposals to the party for settlement, for resolution of the dispute, unless invited to do so by the parties. That's under our Mediation Act. I was asking, I've been talking to Joe a little bit about that. So could we hear a little about the Florida experience in that and evaluation and what issues it gives rise to for you?
Absolutely. If I may, before I do that, if I can wrap up the experience of 30 years in a few seconds, there are statistics. There's a lot of data now available. The RAND Corporation has done analysis. Broad, terrible simplification. I don't think the statistics or the data show that more cases settle as a result of mandatory mediation, but I believe that they clearly establish that more cases settle sooner and with less transactional cost, meaning we get paid less. So just I don't know that that's a fair assessment. I mean, I'm sure a statistician would do a lot more with that information, but that's what I took out of what I have read over the years as our experience. Also remembering that we're unique in the United States, Florida. Most states are only now coming to adopt mediation, and only in the last 10 to 15 years, I think, have most federal courts, without any statutory basis, just invited, if you will, given a judicial invitation that said it should be finished, it is to be completed by a certain date. So that's kind of a wrapping up of our experience based on all of those years. What Turlough was mentioning with respect to the method of mediation, the most controversial or dividing line between methods is collaborative or evaluative. I gather from what Turlough has told me that there's actually statutory limitation here with respect to some of the cases that are put into mediation. In Florida, this is not true in other states, but in Florida, that is essentially covered by a code of professional responsibility for mediators. It has limited impact because you need not be certified by the state of Florida Supreme Court in order to be a mediator. But if you choose to be certified, which I have, then I'm bound by that set of those ethical codes or those ethical principles, one of which is that we are not supposed to give opinions or evaluate the probable outcomes of the disputes. As best I can understand, the theory behind that is and has been that the entire concept of mediation is that it's the parties' process, and if a mediator comes in and puts a thumb on the scale, then it's impacting the ability of the parties to control that process. In an area I know nothing about, which is family, I have heard lots and lots and lots of mediators, very experienced mediators, talking about how that plays out, especially where there's an enormous imbalance among those participants to begin with. So the scales are starting like this. But leaving that aside, I can tell you that in my 30 years or so of being an advocate and a consumer of mediation services, I absolutely considered one of the options that, depending on the case, depending on the parties to the case, I would consider. In fact, I had my regular set of mediators for different types of cases. One of them was a former senior judge of our court, our high court, the trial court, and I knew that he was going to come in and tell my client that he was nuts, he was going to lose his case, and go in and tell the other side that they were going to lose the case, and he beat everybody up. And I knew that in certain cases, that's what I needed, or that's what I wanted. I thought that was going to help. And so I've had numerous, I don't consider them massive ethical dilemmas, but when I'm providing mediation services now in the international realm, which I do more than in domestic, I think that me following that ethical canon that says I'm not supposed to express opinions is a real reduction in the value I can bring in certain circumstances. And so I face it, not every time, but I face it often in my cases where I'm serving as mediator, that I have to come as close to. And you can imagine, it's pretty easy. If you know the lawyer and the lawyer makes the argument and you look at him and say, you really think you're going to win that? Have I expressed an opinion? No, I haven't. So it's not like, that you're locked. But in any event, that's how it comes up most often, again, in Florida. If you asked mediators, experienced mediators from around the country, and I do because I'm a member of organizations with them, the practice is radically different in various parts of the country. California, for example, have you heard of an organization called JAMS? JAMS is, I know, moving internationally. JAMS is basically founded by former judges, and their entire marketing emphasis has always been, we are former judges. If you want mediators who can help you predict what's going to happen, we're your organization. They don't say it quite that strongly because they also, some of them have some ethical limitations that they're bound by. But if you don't get certified, I never found it. I mean, Jerry has passed away now, but he never made any bones about it. He thought that was what he brought to a mediation, and if he never hesitated, and nobody I know ever wanted him to hesitate. So. Too long of an answer, but that's been our experience, and I like a broad array.
It's really helpful that because we, as I say, we can't make proposals unless the parties ask us to do so. But I've seen a proposal that Joe wrote in an international context, not in the Florida context, where he gave proposals in writing to the parties, and that seemed to me to be a good idea. And I think if the parties do invite us in this jurisdiction to make proposals, I think it's good to see those proposals by email and writing. I think that's helpful. May cause some delay, but it's useful. But we reality test as we must. So the question, do you think you can, how do you think that point will work in court? Do you think you'll win on that point? I think is a legitimate question. I don't think that's an evaluation. You're getting close to evaluation, and tone of voice could make it an evaluation.
You don't have the same facial expression that I have.
But the proposal for settlement that you wrote, it did contain a view to the clients, which I thought was useful. And when you're making proposals as to settlement, whether we evaluate or not, and I'm not so sure that we cannot evaluate if the clients ask for that as well. I think the purpose of our legislation is to empower clients, to empower parties a lot. So if they ask for evaluation, I'm not so sure that we cannot do that if both parties want it. When I've been discussing with Joe our different jurisdictions, he mentioned a significant case, the North Miami Beach case, the Surfside condominium collapse in Miami. And two things struck me. He pointed me in the direction of an authority there where I could read up about it. It's multi-party dispute, as you can imagine, when a building collapses. And that dispute was resolved within a year, and it was resolved by the inclusion of non-parties to the settlement. And I wanted to hear, how could you do that? How was that done? So the non-parties contributed significantly to the settlement. Now, how do you do that? It obviously speaks of mediated solutions. Could you tell us a little bit about that case and how the settlement of such litigation was achieved and how parties were brought in?
The collapse was a massive tragedy. I'm sure you at least heard some of the news of it. It was called the Champlain Towers, approximately 12 or 13 stories, and it just collapsed one evening with approximately 100 souls perished in the collapse. I had absolutely no involvement of any kind in the case at all. I know most, as very close friends, almost every lawyer and the judge that were involved. So I speak with staggering pride that just a massively complicated tragedy could be resolved From what I can tell, reasonably fairly and with adequate compensation to a large number of people in such a short period of time. The judge is a close friend. He's no longer a judge. He's retired. He is one of the most aggressive human beings I know in my life. He plays golf. He plays contact golf. I mean, everything about him is aggressive. And he made it crystal clear when the trial bar, my other close friends and colleagues, began to fight each other over who was going to get what and who was going to be in control, that Mike, the judge, was going to be in control. He appointed as lead counsel one of my closest friends from law school and a fellow of the International Academy of Trial Lawyers, Harley Tropin, and they organized a group of, he herded a bunch of cats, and one of the more senior members of the bar in South Florida volunteered to be the mediator. The mediator was agreed to and appointed almost as soon as the case was organized. And the mediation process began probably before he was appointed. In fact, I'd be shocked if he wasn't. And Bruce is more subtle, but every bit as aggressive as Mike. And so between the two of them and the lawyers doing a fine job, they probably did a few things that they weren't authorized to do. They forced parties to be in the proceedings and sessions without necessarily having all the authority to do so. But every possible insurance company that had any possible responsibility to any party was there, and that meant dozens and dozens of insurance companies. The story that is publicly known is that the security company that was responsible for the security funded $500 million of the settlement and didn't need to be sued in order to get that money. And that primarily is the result of information that was exchanged prior to and during the course of mediation sessions. It was not a mediation session the way we think of them, where the parties come together in the morning and they end at the end of the day. Obviously, it went on and on and on. But the combination of those features and 30 years of judges and mediators being fairly comfortable with pushing people that don't want to be pushed in circumstances that I guess deserved it, at least in my view, resulted in something I'm very, very proud of our local bar for doing, and the overall attorney's fees and costs that were incurred in the process were a fraction of what most of those types of disputes generate, and it was. I think it was the result of the extensive experience that everybody had. Some of them, I think, probably orders to compel an insurance company to attend the mediation would have been enforceable, but nobody fought it. They knew that they needed to be there, and it was a remarkable process. The years, I mean, the year's worth of work that was put into a single year was just staggering.
That's a big issue for me when Joe was explaining it, is that there is judicial power. As he said, it didn't require to be exercised in that situation, but they have a statute which provides that the judge can bring in the insurance companies. And I think, Joe, it even goes further, that the judge can ensure through, if necessary, through testing good faith in participation in mediation, can ensure that the insurance company attendee arrives with sufficient authority to settle the case. And in my experience, mediation here, well, we don't have the authority to compel anybody except in that rare situation, personal injury situation. But certainly you can't bring in other parties here. And I have seen situations in my experience, and probably in your own experience, where it would have been great, shareholder dispute, for example, maybe a family under pressure, where it would have been great to have had a bank involved in the mediation, making a contribution to debt write-down, perhaps, to facilitate the parties in moving apart and moving on. So it's a very interesting concept. All I could suggest in that one particular case I'm thinking of is that we would write to the institution and invite them to attend with their legal representative. But it didn't work, in fact, and so there's very powerful legislation in Florida. Obviously. One of the other things that I would like Joe to explain, but we might move a little bit into the idea of negotiation, which I strongly believe is a core value of the bar, a core expertise of the bar, becoming much more popular subject of discussion, the idea of mediation, of negotiation, how we negotiate with each other. Harvard program on negotiation devotes a lot of time to this very successfully. So I believe it's a core expertise of the bar. And of course it is an ADR solution. And we've been doing it all the time. And caught my eye that Abraham Lincoln regarded, he was a circuit lawyer in Illinois on the 14th Circuit. And he regarded peacemaking as one of the very important attributes of a lawyer and believed in that. So we might talk a little bit about negotiation style and things like that. But before that, I wanted to ask Joe about evidence giving at mediation. Do you have people giving evidence at mediation? How does that work? And what about advocacy at mediation? What's your experience of that? And can you help us a little bit with that?
I don't know about helping, because we do everything. Some people do it well, some people just get through it, and some people do it very poorly. But and we have lots of experience with all three of those. Advocacy obviously is advocacy. We engage in advocacy in our daily lives. What has happened with all those 30 years of experience in Florida, from what I have observed and heard, is that not surprisingly, there are different approaches to advocacy within the mediation process by different lawyers. Forgive me, I want to share my favorite experience when I was an advocate in a mediation. I was brought in to help try a case in Sioux Falls, South Dakota. This is Middle America, folks, and I'm sort of Middle America. And it was just an awful defamation case. And literally, a cardiac surgeon had pretended to be a nurse and wrote scathing letters about a cardiologist to the families of patients who had died. I mean, it's awful as you can imagine. And the evidence, we had the evidence to prove that he did it. And so we went into this massive mediation. There were the hospital, the doctor, several assurance adjusters in different places. And because we were getting ready to try the case, and I was not going to be responsible for actually attending and negotiating, I got to just make the presentation. And I walked in and I said, we have conducted 6 mock juries. I have talked to at least 25 people here in Sioux Falls and explained what your insured did. And I looked at the doctor and I said, they hate you. And I walked out. So, obviously, I have one partner who doesn't think a mediation is finished until he has stood up, yelled at the mediator, and slammed the door and walked out. Others, obviously, that is, that just doesn't make much sense in most mediations. I kind of think that the sort of the common thread that I've heard Another example I've heard, one who refers to it as "let's go scare the bejesus out of the adjuster sessions." There are every kind of approach that you could imagine. But if you think about it as though you are representing yourself and you're asking your boss for a raise, that might be the sort of approach to advocacy that you want to carry into it, because that's what you're attempting to do. You're not asking Judge Barnable to order or to award damages judgment against this person. You're asking this person to voluntarily pay that money.
You're seeking to persuade.
It's still advocacy. It's still persuasion, but it's you need to know your audience. So that's, I mean, there is no one way. But now, I'm sorry, you also asked about evidence. Same thing is true of how they're conducted. In my former firm, where we had where they have major cases involving millions and millions of dollars, they will very, very commonly go in and make an extensive presentation, because it is their chance to make sure that whatever information they are trying to communicate to the decision maker on the other side is not being filtered through that decision maker's advocate. That's one of the benefits of mediation. The communication to the decision maker from the other side is formalized in a confidential setting, and it's a very, very effective approach over years and years that I've observed. Now that I'm doing it as a mediator, I can tell you I've got a massive mediation coming up this month and next, involving millions and millions of dollars of small transactions. I mean, average maybe $1,000 to $1,500, and millions of dollars over many, many years. And because of the various battles and how costly and how difficult it will be for any court to sort through that, the parties themselves decided to exchange information and both retain statisticians, and they took a 1-year sample, and they're extrapolating the results of that 1-year sample over the period of the statute of limitations. And they've exchanged all of that information before, they've given it to me to read before we have our first mediation session. Now, we've had lots of conversations. Lawyers have had conversations together. When we get together, there's not going to be any presentation, because it's already, that information has been exchanged. In construction cases, very often, the engineers that are going to be critical to the outcome of the case will be brought in one form or another, either by reports or by, I've been present when competing experts sat in the room with a mediator and counsel and decided and discussed the issues that were going to be tried. So it's almost as wide an array of experiences as you can imagine. I'm sure I haven't even touched on how many different approaches different advocates take. But I can tell you that lawyers representing plaintiffs, have come around to understand that there's a better chance they can resolve their case sooner for their clients if they take mediation seriously, and if they prepare for it, and if they try their best to adjust their advocacy to that form.
I was well. Thanks for that, Joe. And I'll avoid the terrible temptation to seek off and ask you about your experience of mock juries, which I do find intriguing. But just moving on slightly, there are many mediators, distinguished mediators, in this room already, and at our bar, well, I speak for myself, but I also have the impression that others of us do it. Is it the practice at our bar to try and now avoid plenary sessions and the opening of the case by advocate, by the bar, to the mediator in front of the clients? Certainly, I could say my own experience is, well, opening a case, we're taught at the bar to open a case fully. It's a big advantage, a big moment in persuading on behalf of a plaintiff. And the only discussion I have ever heard about the opening of a case is whether to avoid opening it too high. But I never heard anybody argue for a moderate conciliatory opening. And that's, so we don't have much experience of moderate conciliatory opening. And when we come to mediation, the temptation is to escalate. I've certainly found it's taught in certain schools. Some of us had been taught as mediators, gather everyone around, have the plenary session. I gave it up. I'm wondering, first of all, maybe second of all, what Joe thinks about that. Am I right in thinking that our style has developed to avoid the plenary session?
Is it all for the same reason? I mean, mainly because you just think it escalates too fast and to bring them back down is too hard? That's the way Turlough described it. Yes?
Okay, well, just for the microphone, we repeat Michael's question, which in essence is to Joe, do lawyers make good mediators?
Can they be trained out of being bad?
And the supplemental question is, can they be trained out of being bad mediators?
It's pretty hard to retrain a 71-year-old lawyer. First of all, I'm relatively new to the actual service of the mediator process. And I am very aggressive, just naturally. But also, I am very impatient. And there are certain things that are simply essential. And all I can say in my own defense is that I'm still not patient, but at least now I will recognize that patience is occasionally a virtue. And so am I retraining? I don't know. It is difficult. I've been exposed to enough. You see, we don't have a bifurcated bar. So the same license that entitles me to go try lawsuits entitles any lawyer in the state to go try lawsuits. And the same license entitles me to go mess up as a mediator. And so I spent a lot of time trying to retrain. I took first of all, the Florida Supreme Court course is a multi-week process that takes a long time, and they do try to beat some of those things out of you. And I didn't let them. But I also took the Cedar course, which was fabulous to me. And one of the classics is, as a barrister and a trial lawyer, I've always said that we don't emphasize effective listening enough because we're trying to control the courtroom. And I think that's true, but I know that is true in mediation. I can't control that mediation room. I shouldn't be trying to control that mediation room. And so my guess is that there are lots of really terrific mediators that are not lawyers and are much more effective than me. I think what happens, I have a lot of former judges that are very close friends, and in Florida in particular, but in all through the states, retired judges are a large percentage of the mediation bar. I think the Florida certified mediators, there's almost 6,000 of them. My guess would be that at least half of them are former judges. I don't know. I mean, because now what you're talking about is not just the skills, but also the particular unique experience of making the decision for people. I don't know whether we ultimately make good, bad, or indifferent ones. Probably most of you were human beings before you became barristers. My wife suggests that I wasn't, so it's probably not likely that I'm teachable or trainable, but in sophisticated cases dealing with complicated business disputes where aggressive business people are the ones that are making the decisions and have to make the decisions, where a risk analysis, litigation risk analysis, can be effectively employed. I don't think I'm committing malpractice just by engaging as a mediator in that setting. Now, if I was to go and try to mediate a family case, first of all, they'd have to commit me, but secondly, that would be per se negligence. Now, I have to tell you, one of the interesting things about this whole thing about having the session, the plenary session or not, I think if I'm correct in what I hear, most of the California mediators have reached the same conclusion you all have. I don't think many mediators in California even consider plenary sessions. I'm new enough to the process so far that I still reach out to the lawyers in every single case and ask them, what do you think? Will this help? Will it hurt? How do you want to go about it? And, good lawyers usually, help, don't steer me wrong, and we give it a shot. I try also to meet the clients, the parties, before the sessions, because that also at least gives me some ability to judge it. But a lot of that is harder for barristers because you have a lot of the rules that I don't have. I can pick up the phone and call anybody I want to anytime. One of the beauties of the mediation is that there's no prohibition against that ex-party communications. There's no prohibition. The only requirement is that I got to keep it confidential, and I can't share it with anybody until they tell me it's okay to share it. So that's I don't think I could tell you whether I prefer one or the other, or how often I do one versus the other. I think it's almost dictated by the lawyers for the parties.
I think this is a very interesting discussion. I don't think actually we're very far apart. As Joe was talking there, I do think trial lawyers make very good mediators. Maybe I would say that, but I do believe that. I believe the presence of trial lawyers at mediation, in my experience, has been invaluable. And I think the communication, the worthwhile communication, the conciliatory communication, the contribution to solutions rather than the adversarial conversation, that comes in caucus sessions, the private sessions between the mediator and the trial lawyer and the client. And I found it very effective, and my experience is very helpful. People will help. So when the question is asked, not how great is your case, but how would you help me resolve this, the answers have always been very forthcoming, and the presence also of the trial lawyer making judgment calls being able to say to the client at the crucial stage, here's my view. I found that invaluable. But I don't think we're far apart in that. I think we arrive at the same conclusion by slightly different methodology. And what I've also found useful, the preliminary sessions, immensely useful.
Do you have limitations as to, because you're barristers as opposed to solicitors, in what you can do when you're serving as a mediator? I mean, when you're serving as a mediator, you don't have to take instructions from. No. You can't take instructions.
No, you can't.
Okay.
No.
Okay.
You're an independent contractor, quite unconflicted. I think that's a great advantage to our bar. We're independent contractors. Independence is crucial to us. We're therefore unconflicted, in many situations, and that's a huge advantage to us as well.
Before we leave this subject, I'm going to step out of my expertise because I've already told you I know nothing about family law, but I do have a lot of former judges in particular, but also lawyers that do family work. And one of the things that totally surprised me was that more than one of them, several of them, said that Zoom or virtual proceedings had made it possible to allow more plenary sessions because it separated out some of the imbalance and some of the resistance to communicate, and that I've already gone beyond my ability, but I've been told that, and it was completely counterintuitive to me. I thought this, does that make sense? But that's what I've been told. I think probably that's mostly saying that the wives feel more comfortable speaking honestly when they're not in the physical presence of the husbands.
You're talking about, when you say plenary sessions in that context, you are talking about a private conversation.
No, not necessarily. Plenary session on Zoom where the spouse who would, if they were physically in the room, would not say things. Says them. That's what I've been told.
It is a wonderful tool, the Zoom call. I find it useful for, I think particularly in the private conversation with one side prior to the mediation. When I use this kind of idea that I floated this with you a little bit, but I say sometimes to people, very often to people in the initial session, look, you have been focused, our system requires you to look back to the past with a view to finding fault. And that's the process with which you have been, the psychological process with which you have been engaged. I look back to the past with a view to finding fault. That's a particular way of looking at things, and it's a particular burden to carry. You're moving into a process which will require you to think forward about how you might shape your future, and not to find fault, but how you will try to reach the other side, how you'll now be concerned with the other side's needs and interests, because you must understand those. And the reason I like the break between that conversation and the mediation day is that I think you need time to start thinking that way. And we share, all of us, Joe has this take on it as well as I, the curse of the advocate. Finding the point, you say at 2:00 in the morning, and I say
closing arguments.
So sometimes in the journey home from court, you find the point. But it's natural to human beings to continue a process of thinking beyond the time you thought that thinking would be, or that thinking was particularly required. So with clients, I think it's useful. Start the process and say, look, we're running out of time. We could talk for hours. We have talked for nearly an hour, and we have talked for hours and hours. Lawyers engage this way conversationally, I think. And information is transmitted almost neurally between lawyers, so fast sometimes, and is very helpful to trial advocates. I wanted, because we build it, that we would have a passing, with some reference to the Legacy Act. I just don't want, far too big to deal with at this session, far too complicated. I'd encourage people to continue to think about it, to look at that act and see it perhaps not as the end of dialogue, no, definitely not the end of dialogue, but maybe as a contribution to dialogue, and that might help, because we do need the reconciliation on this island. We absolutely, all of us, want to see that. But coming from the peace process, there are a number of ideas that I do like, but maybe just time for one of them, which is that Father Alec Reid, who is a major figure in the peace process, wonderful BBC, I think RTE documentary on him, and then a piece in a Spanish documentary called Pelota Vasca, or Basketball Skin on Stone, by a director called Medem, M-E-D-E-M. Interesting documentary on the issue in Spain, Basque Spanish issue. Even that language is contested in Spain. Even that designates. So we need to be terribly careful about language. I'm not endorsing any view of language here. But he said, they obviously said to him, what is the key to conflict resolution? That's the only question. You don't even hear the question that Alec Reid was asked. You just hear the answer. And the answer is, and it's his only walk-on part in the documentary, and he said something like this. This is quite close to what he said, but not just bang on. He said, the key to democratic conflict resolution, dialogue is the key to democratic conflict resolution. Your enemy or your opponent says something. You know that it is true. You hear that it is true. That's where you can key in. And then you have the beginning of a relationship. And then in the documentary, it was further elaborated. He believed something then started beyond the terms of the dialogue. His colleague Jerry Reynolds said he believed that was the space which allowed God to work. People may not, in a secular age, may not agree or will agree or disagree with that, but I think the idea is that this is from the most experienced man in intense conflict resolution. Tremendous work done by him. The documentary is very moving. Tremendous work done by him. But he's saying from his experience that it's a dynamic. Dialogue is therefore energy. It creates something. I think he's saying beyond itself. I'm certain he's saying beyond itself. And the driving force is the truth. And I was saying to Joe, we were talking about this, truth in negotiations. The ethical requirement to be true, but why be truthful? But why is that so? And we're lucky at the bar. We know our negotiating partners. But why is that so? And I think it's the closest I can come to it at the moment is I think neuroscience will help us a little bit with this. But the closest I can come to it at the moment is in court. Sometimes you hear people say something, and you can hear a pin drop. There's absolutely no doubt that you are in the presence. Sometime, maybe an abuse case or something like that, the person is actually back there. Sometimes hard to watch. And the cross-examiner has a very difficult task at that stage. There's something, it's not intellectual. There's something in hearing and speaking the truth that is very powerful. And we'll close on that issue by asking Joe and all of you for views, anything that has cropped up. But I'm anxious not to take up people's valuable time. But I would like to hear Joe on that idea of negotiations, truthfulness in negotiations, what it does. Has it a place in negotiation?
I do not consider myself particularly skilled as a negotiator. And the reason is because of my practice. I represented for most of my practice extraordinarily talented and self-confident business people who really did not expect me to either develop the strategy or implement the plans for the negotiations. They wanted me to try the case if it wasn't going to get resolved. So I have not spent as much time as many, certainly not as much time as Turlough has thought about these issues of conflict resolution. But what I can tell you is that above every judge in the state of Florida is a single sign, and all it says is, "We who labor here seek only truth." And I have argued in a different setting, the arbitration world, where very legitimate, smart, well-meaning people believe that the arbitrators role has nothing at all to do with the truth. It is purely to resolve the dispute that has been brought to that arbitrator. I've had discussions with people I admire greatly, and I do not question their commitment to that. I do question whether or not it is the best use of arbitration. I think that the truth is, in fact, the goal, or should be at least a part of the goal in any dispute resolution process. As an outsider, but one who has grown to love Ireland greatly, and as an honorary bencher, and I think you have a sense for the depth of my relationships with your colleagues here at the bar and the bench, and soon to be the bench. Congratulations. All I want is to know if there's anything I can do to help. Anything I can do, anything outsiders can do to help the process. Is there anything that we think can be done to help keep, well, first of all, obviously keep the peace, but then also advance the reconciliation in a fair and just way? And so to the extent any of you thought that was something that I or anybody else from who is not Irish but loves your country and your people could do, I would love to hear about it, because the idea of going back to the Troubles is just impossible. It just can't be allowed to happen. And to be dealing with such talented advocates and advocates who are exploring the role of peacemaker in within the dispute resolution system that you live, I would love to know whether there's a role for the bars in that process, and if there was anything I could do or we could do to help encourage it.
On that note, I suppose on behalf of us all, I would say huge thanks to Joe Matthews. At his insistence, I have soft pedaled somewhat on his achievements. We are lucky to have such a distinguished person amongst us, such a generous, good-hearted sharing of information, which is valuable to us as we develop our expertise in mediation and negotiation, advocacy generally. I can't thank him enough. It's always a pleasure to listen to him. Thank you very much for being here amongst us. And I'd ask everybody to give you a round of applause and appreciation.
Thank you for listening. For more from the Bar of Ireland, please visit lawlibrary.ie.